Welcome everyone to our LexisNexis Legal Edge Competition Law webinar. I'm Jennifer Bannon and I'm the Strategic Projects Lead for LexisNexis, and my background's in competition and consumer law, having worked at Allens and at Sky TV in the UK and Johnson & Johnson Medical here in Sydney. So I'm really excited about today's discussion. Before we begin, I'd like to acknowledge the traditional custodians of the land on which we meet today. I'm based in Drummoyne in Sydney and I'm on Wongal land, and I'd like to acknowledge the Wongal people and the traditional custodians of the land on which you're based today, and I pay my respects to elders past, present and emerging. So competition law remains a hot topic. It's never off the agenda or out of the headlines, and not the least because of merger reforms that have just been announced by government. And the ACCC, under the leadership of Gina Cass-Gottlieb, who's now in her third year of her term, continues to be an active regulator, an enforcer of the law, and a very strong advocate for reform. And to encourage engagement and interactivity in today's session, we'll be posting some poll questions in the, on screen. So please look out for the first question that should be coming your way now. We have over 450 registrations for today's webinar. And around 200 of you are from private practice, and I think that's almost equally matched by in-house or corporates. So it's obviously something you're interested in and want to hear more about. So today we'll be discussing merger reforms and what it means for Australian businesses and the regulatory landscape. We'll touch on some of the ACCC's enforcement priorities. We'll cover the new super complaints process, and we'll talk about the uptick that we've seen in private competition law litigation, and we'll also cover the competition review of non-competes and other restraints. And throughout each topic, we'll endeavour to provide some tips on how to deal with the ACCC, leaning on our expert panel, and I'd like to extend a warm welcome to them now. Please welcome Felicity McMahon, who's a partner in the Allens Competition and Consumer and Regulatory team, and Felicity advises on all things competition law, but particularly mergers. So no doubt Felicity will be even busier than normal in the lead up to these reforms coming into effect on the 1st of January 2026. Please also welcome Trent Sinner. Trent's the Group Executive Legal and External Affairs at TPG Telecom. That is quite the mouthful, Trent, that title. But Trent's been a telco lawyer for over 25 years, and he has firsthand experience, for better or worse, of having a merger blocked by the ACCC and then having to go to the federal court for a declaration for it to basically be cleared. So welcome, Trent, as well. And finally, welcome my colleague, Chloe Hammond. Chloe's the Senior Legal Writer for Practical Guidance Competition, and Chloe's got a background in competition law as well, having worked at KWM and Ashurst and in-house at BlueScope. So it looks like all of the above. So you're interested in hearing about all things, but interestingly, non-competes and other restraints you're very interested in hearing about, as well as merger reform. So that's great to hear. Now, with the introductions now done, please, if you have any questions, pop them in the Q&A and we'll endeavour to answer those at the end, time permitting. But getting into merger reform, I'm sure you're all aware now that in April, the Treasurer, Dr. Jim Chalmers, announced the government's intention to introduce the biggest reforms to merger settings in 50 years. No surprise there, really, because the Trade Practices Act only came into force 50 years ago in 1974. But he's sort of billed these reforms as being faster, stronger, simpler, more targeted and more transparent. So we're wondering, will it live up to these hefty expectations? And that's what we'd like to talk about today. And as probably everyone knows, merger reform's been on the cards for a while. Rod Sims first proposed them in 2021, and the ACCC's received some, but not all of what it asked for. It didn't get an official call-in power, and there's no reversal of the onus of proof, but the ACCC is sort of being put forward as that single decision maker on all mergers, and with some additional powers and scope. And I think there's been plenty of conjecture amongst competition lawyers and law firms and journalists about the ramifications of the reforms. Some say these sweeping reforms are welcome and they'll result in clearer timeframes. Others are more sceptical about the need for the reform and whether there was evidence to support giving the ACCC more powers. And some are concerned about sort of this front loading of the process and having to bring in economic evidence and expert reports and sort of more information at the beginning of a merger notification. So yeah, excited to hear thoughts about whether the reforms are welcome or not. And in terms of the rationale for the reforms themselves, Dr. Chalmers referred to a general decline in competition in Australia as a key reason for the reforms, and noted the sort of increasing market concentration and increasing merger activity by some of those big players. So what are the changes? We will be providing a link to an infographic we have subsequent to the webinar, but Chloe will talk us through the key changes. And just while she's starting that, there'll be the next question about whether you think these reforms are welcome.
Sure. So the government is proposing to replace our current voluntary merger regime with a formal, mandatory and suspensory mechanism from the 1st of January 2026. This will mean mandatory notification of deals above certain thresholds based on monetary value and market share, though these are yet to be determined. As Jen mentioned, the ACCC will be responsible for a single merger control pathway, replacing the 3 avenues currently available, being informal merger clearance, merger authorisation and declaration from the Federal Court. In terms of review, ACCC denials of merger clearance will be reviewable by the tribunal on a limited merits basis, and judicial review will be available from the Federal Court. We will be seeing filing fees. These are yet to be finalised, but proposed to be in the range of 50 to 100,000 with an exemption process for small business. There will be upfront information requirements and also set timelines for review. Timelines are also yet to be finalised, but it looks like phase 1 at this stage will be a 30 business day review with the option to fast track for non-contentious mergers to try and get that done in a 15-day period. You would then move to a phase 2 review if the ACCC expresses concerns from the phase 1 review, and that is slated to last up to 90 business days. And there may also be an ability for the ACCC to stop and extend the clock in certain circumstances. The ACCC has been given additional weapons to tackle creeping and killer acquisitions, and the merger test itself is also undergoing reform. So the current prohibition on mergers which substantially lessen competition under Section 50 will be broadened, and there will be new economic principles brought in to replace the merger factors in Section 53. And the ACCC will also now be applying the test based on its reasonable belief. The changes incorporate almost all of the proposals for reform which the ACCC has advocated for, other than the proposal to reverse the onus of proof, as Jen mentioned. So the onus will remain on the ACCC to prove that the deal would be likely to substantially lessen competition, and on their ability to call in mergers that fall below the set threshold, but which they still have concerns about, although query whether they essentially have this right in all but name due to the suite of other reforms that is being proposed. In terms of next steps, there will be a period of extensive consultation now to round out many of the details that still need finalisation, and we expect draft legislation towards the end of this year.
And so they are sweeping reforms. There's almost no aspect of merger control that hasn't been touched, from the fees and the filing and the process and the test and the merits review. Felicity, you've advised on many mergers and acquisitions, both in Australia and internationally. What are your thoughts on the merger reforms, and what impact do you think they'll have on M&A activity or the regulatory landscape and the work of competition lawyers here in Australia?
So, Jen, I think the promise from the paper that the government published is a really seductive one. And it's really quite attractive because you mentioned it in your opening spiel when they're promising a regime which is faster, stronger, simpler, more targeted, and more transparent. But I think, as we all know, there's a lot of detail still to be worked out. And I think the devil really will be in the detail as to whether or not the regime in practice delivers on that description. So perhaps if we could just talk through a couple of areas where I think there is a great potential for reform to offer greater certainty in notification thresholds. Are you in or are you out? How long is it going to take? Those key things that are really critical to a business when you're deciding whether or not to endeavour and embark on an acquisition which has an ACCC dimension to it. So let's talk through a couple of those. So first of all, thresholds. Now, you and I have both worked around the world and are pretty familiar with the different types of thresholds you can get. And the ones which are obviously easier are those monetary thresholds where you know really quickly whether you're inside or outside the regime. Now, we don't know what the thresholds will be here, and they may be a combination of things. So they may be a combination of revenue, profitability, and transaction value thresholds, which are pretty easy to determine, although that we know that there's lots of rules about how jurisdictions calculate those overseas, which we don't have here. So that needs to be worked out. But I think the problem comes down to including a market share threshold in the thresholds, because as we all know, reasonable minds can differ about what is the appropriate scope of the market. And that does result in potential uncertainty about whether or not you're in or outside the regime, and getting essentially into an argument with the regulator about whether or not they have jurisdiction based on that test. So that can be a source of uncertainty. We also know that there's going to be this 3-year look-back rule, which means that basically you have to aggregate all the transactions in the past 3 years to work out if the thresholds are satisfied. Now, presumably that's supposed to be about the market share threshold. So you're supposed to add up all the shares you've acquired in recent years so that you can work out if you've satisfied that jurisdiction or not. But will it apply to target revenues? Not sure. So there's a bit of uncertainty there. We also know that there'll be additional targeted thresholds which might be announced and introduced if there's concerns about mergers in particular areas. So that's another area of uncertainty. So that's thresholds. When we look at timing, one of the sort of the downfalls of the current informal regime is that lack of certainty about timing. And I think there'd be a lot of support across the business community for much greater levels of certainty in the timelines for review. But what we've seen so far from the government is that there are going to be opportunities for the ACCC to extend the timeline. So first of all, at that notification point, the ACCC has the ability to work out and determine when there's a valid notification, so they can hold you in that process before starting the actual review. And then there'll be an opportunity to stop the clock when it wants more information, and then also with the agreement of the parties. And we certainly know from the authorisation process that often the parties agree to extensions of timelines, because otherwise you're obviously going to get a no from the ACCC. So that's an area where we have a breakdown in those, or potential breakdown in that certainty of timing. The next thing is sort of transparency. I think when you read the tea leaves that have been left in the document from the government, is that transparency doesn't necessarily mean transparency for parties. It means transparency for the ACCC. So it's about giving the ACCC upfront information in your filing rather than necessarily information rights for parties. We've seen that the ACCC is going to be required to list certain information on its website and give write out its reasons. But what we haven't seen is it go further than that and say that parties will have access to the file, for example, that you might get access to in other jurisdictions or those rights. We haven't even seen it go so far as to say all the third-party submissions which are lodged with the ACCC will also be made available in the way that they're currently made available in the merger authorisation process. So it hasn't mentioned any of that at the moment. And the reason why that's really important, Jen, is because, as you've pointed out, there's going to be a limited merits review appeal to the tribunal. And Trent obviously knows more about this than anyone, having gone through it. And also gone through a federal court process, is that really does limit the ability of the parties to test the evidence and cross-examine witnesses and adduce further evidence. So from a practical perspective, I think this is going to mean that it's going to cost more to do a merger because parties are going to have to front load all their evidence as they do now in the merger authorisation process, both in the filing itself, but also because you are going to have to expect the worst and put all that evidence on to the case file so that's available to you if you do appeal to the tribunal.
Lots of issues to still work through, and I think one of the questions that's come through on the chat is whether any of us as panelists are concerned about the judiciary no longer being able to review the ACCC's decisions. Well, I think you've just answered that in part, that having to front load is a slight concern, and that if you can't adduce further evidence, that could be potentially problematic as well. And I'm sure there'll be lots of barristers out there upset that they won't be involved in as many merger reviews. Yeah. Felicity, were you going to say something else there?
Yeah, and Jen, I have to say it's not clear yet how much scope there will be to introduce new evidence. So the paper at the moment talks about there being a review to the tribunal on a fast track and a non-fast track basis. And so that is suggesting that perhaps there's, and the fast track process will be purely on the basis of the material that is before the ACCC. It's difficult to understand or to know at the moment what the gap is between fast track and non-fast track in terms of whether you'll have scope to introduce further evidence. But if it's the way it happens at the moment, then it will be very limited.
And Trent, as we mentioned before, you've been involved firsthand in having to deal with the ACCC, with the TPG Vodafone merger being blocked by the ACCC, and then Vodafone appealed, and you were successful in getting a declaration that there was no SLC at that point. We'd love to hear your tips on how to manage mergers with the ACCC, and from your experience, any thoughts or concerns in light of the proposed changes?
Yeah, thanks, Jen. Look, I think probably as a general comment, I would say that the merger reforms are clearly aimed at providing greater power to the ACCC and control to the ACCC, and it seems to me that the clear impact on that is going to be a loss of flexibility to the parties and possibly increased time and cost to the merger parties. And Felicity made the point of front loading. So that was, if I jump to the more recent case that we had, which was the TPG Telstra network sharing deal, where we went for an authorisation. That one, we did have to front load the process much more than we might have otherwise, because if it did go to the tribunal, we knew we had limited opportunity to introduce new evidence. That really did increase the amount of work. Clearly, the cost meant more for the ACCC to consider as well. And just on, so that's one point. On timing, which is the other one, but I did a quick check yesterday on the time it took for the approvals for both the TPG VHA merger and the more recent one. On the TPG VHA merger, it took 9 months for the to be not approved by the ACCC, and a further 10 months before we had the federal court judgment. That was an informal clearance process. There was a lot of evidence put forward to the ACCC, but it wasn't front-loaded to the same degree that we probably were thinking about when we did the next one. On the next one, the TPG Telstra regional sharing deal, the authorisation took 10 months and then a further 6 months in the tribunal from the start of the process to the decision. So those timeframes are already pretty long. My concern, I guess, is, and Felicity touched on it, I think if two things could happen. If the thresholds are not right for the ACCC, firstly, they'll be catching many more potential mergers that might have otherwise not come to the ACCC, or might have been waved through on an informal clearance process or otherwise. That could mean further costs and delay. That will definitely mean further costs and delays to business if they're doing much more work in the merger process. Secondly, I don't think we can underestimate the resource burden on the ACCC itself. They're going to need to employ new lawyers and economists and build their teams up to manage the influx. I think there was the idea is to try and keep the number of merger applications at about the same number they have today, but again, it's really going to depend on that detail. So too low, they're going to get a lot more in, and I would imagine part of what the ACCC would like out of this process is to see more of them. So clearly there'll be more coming through. That's my view anyway. The taking away of the court processes. So look, you know, I thought the tribunal process we went through was, even though it didn't have quite the same procedure and we weren't able to put in as much evidence as we would have liked when we got to the tribunal, it certainly felt like a very robust process. So I'd have to say that if the tribunal is the only place you can go, provided that there are the right number of protections for the parties that come into these new laws, that might not be such a big problem. I always would like the idea of being able to go to court and having a full court-run procedure to know that you've got that last sort of avenue of decision making. But if that's not going to happen, then I think what needs to occur is the tribunal, the rules that are put in place for new evidence, for potential cross-examination, might need to really be looked at in respect of the tribunal process.
And thanks, Tran. And interestingly, our audience overwhelmingly thinks these reforms are welcome. So hopefully those sort of concerns around timing and transparency and limited merits review and so on can be worked through over the coming 18 months to provide the regulatory certainty that businesses need. And another change, moving on from sort of merger reform, but another change that our audience are particularly interested in, which we'll get to in a moment, on non-competes, just shows how active the ACCC is at suggesting reform. And another change that's just come into force is around the super complaints process, or in the legislation it's known as a designated complaint. And I understand this new framework was established to allow consumer and small business groups to identify concerns to the ACCC, including systemic issues of concern and detrimental practices. And the ACCC is then required to investigate and report back on that complaint. And this is a process that already exists in Canada and the UK. Chloe, how's this been implemented in our legislation here in Australia just recently?
So the amending legislation commenced earlier this month, and what it does is insert a new part XIE into the Competition and Consumer Act, establishing the designated complaints framework. which allows consumer and small business advocacy groups approved by the minister to submit designated complaints on significant or systemic market issues affecting consumers or small businesses and relating to breaches of the competition or consumer laws or relating to the ACCC's exercise of powers under the Act. Designation of complainants sits solely with the minister, and the names of entities approved will be published on Treasury's website. A complaint needs to be made in the manner and form approved by the ACCC and needs to also meet any prescribed requirements made in the minister's determination. And the ACCC is obliged to respond to a designated complaint within 90 days of receipt.
And Felicity, what do you think this will mean in practice?
So, Jen, I think it just really means that there's a more formal process for which complaints by these recognised bodies, designated bodies, are assessed and streamlined and prioritised in the ACCC. So I think what will be really interesting will be to see who the designated bodies are, because that will give an indication of potentially the nature and industries where the complaints may come from or be focused on. In the UK, it's pretty broad. There are a number, including sort of in the beer space, which led to looking at beer supply agreements. There haven't been that many that have necessarily been prioritised and followed through by the CMA. But look, I think it's another way where there's a bit of convergence internationally. We've borrowed an idea from, a neighbouring sort of sister regulator overseas, and but really, I think it will be interesting to see who's designated.
Absolutely, one to watch in the coming months to see, how quickly we can see a designated complaint come through. And turning now to the ACCC enforcement priorities, which are announced each year in March at the CEDA conference. And this is sort of where businesses and legal advisors get a bit of a heads up or a practical roadmap of what the ACCC is focusing on for the year ahead. And we might put the next poll question up around what you think are the most important compliance and enforcement issues from a competition perspective. Greenwashing, sustainability is there again this year, as well as sector-specific scrutiny, price inquiries and market studies and the like. We've just seen supermarkets be listed as under scrutiny. Cartel conduct's always on the cards as an enforcement priority, or you might think all of those are equally as important. But I think what we saw from the priorities this year was a reflection of economic conditions, the cost of living crisis really sort of prompting the ACCC's sort of back to basics approach here, and focusing more perhaps on consumer issues and a focus on essential consumer goods like supermarket goods and services, groceries, food, gas and electricity. Trent, you're there again with telcos. But also it's got that sort of ongoing interest in anti-competitive behaviour. So with those, a few new sectors coming under the microscope, I think we're seeing that both across consumer and competition issues. And in the consumer space, I suppose, a bit more of a focus on things like scams, which are more prevalent with use of email and the internet and online commerce, but also a continued focus on enforcement of some of those new consumer provisions and the unfair contract term prohibitions. So, Trent, for better or worse, you've been nominated again as an industry in focus. What does it feel like to be under the ACCC's microscope and in scrutiny, and do you have any tips or recommendations for other businesses who might find themselves in a similar situation?
Yeah, well, I think every year we are mentioned, and that's no surprise given, we're everybody is a telco, almost everybody is a telco user, whether it's your home broadband or your mobile. So there should be a focus. I think the first thing I would say is that, you know, we're clearly, our policy is to be compliant, and we have many people working across the company in compliance and legal whose job it is to ensure that we are so. So really, as a company that attempts to be compliant, and there's lots of things that happen in organisations where you might fall foul in that there's a process that might fall over. But when you're thinking about the really big ticket items, you know, is your advertising right? Are your products set up right? You know, we spend a lot of time working through those to ensure we're compliant. So really, what I would say is we welcome, to some degree, being part of the enforcement priorities of the ACCC, because it creates a level playing field. It means that if anybody wants to enter the market and isn't going to play by the rules, the ACCC will be there to keep it fair. I do, however, have a general concern, I guess, with if there is a focus on an industry that the regulator is looking for things, and that may not be the right approach. And reasonable minds can always differ, as we heard earlier, about what might look like a compliant or non-compliant either piece of advertising or process. And you know, it just comes to mind a few years ago we had a debate with the ACCC about using the word unlimited for mobile phones. And when I say debate, we launched the word unlimited, and then we were told fairly swiftly that was if we continue to do so, there might be consequences. What we pointed out to the ACCC was that this is a word being used right now in NBN plans where they do have effectively the same construct. It was just new to telco, and it was certainly a concern that they raised. I think if you fast forward to now, there are similar words being used in mobile without anybody getting concerned about it today. So it was almost, you know, it was a journey that they had to be taken on to realise that, in fact, what we believe to be compliant probably now is considered compliant, but because it was new, it wasn't. So these are the sorts of interesting things that can arise when you're in the focus of the ACCC, and clearly, you know, that there will be differences in opinion.
Absolutely. And in terms of some of the other enforcement priorities, Felicity, ESG and sustainability is again on an area of focus. What are the concerns here?
Yeah, I mean, I think the ACCC knows that consumers are increasingly prioritising ESG credentials when they're buying goods and services. So we all do. We all want to buy a product which has a low environmental footprint and, you know, doesn't involve slave labour, and is good for us as it is the people who are involved in the manufacture of it. And the ACCC knows this, but it doesn't just see it as a consumer issue, as a mis-selling issue. It sees it as a competition issue as well, because its view is that if there are competing suppliers of products who are selling the benefits or the ESG credentials of their products, then they need to be accurate. It's not fair that one company is doing the right thing and putting its money where its mouth is on ESG terms, and another company isn't, but is still trying to trade off having those credentials. So it does see it as very much part of its dual hat to protect the consumer, but also to protect the competitive process, which really does make sense. So, you know, we had the final greenwashing guidelines issued last year by the ACCC. We saw a few changes there. And we also know that the ACCC is planning to issue some guidelines on how to assess public benefits of sustainability measures in the context of conduct authorisations. And I think that's, you know, become a thing that the ACCC has been looking at in authorisations. And we certainly had the merger authorisation last year in Brookfield Origin. So where it sort of flagged a comfortable its comfort with dealing with those issues. So, you know, the legal regime in Australia exists to do that sort of thing, and that's quite unique, I think, internationally. And the ACCC has flagged that it's willing to do the work to consider whether or not the public benefits of a merger or an authorisation from an ESG perspective should mean that they outweigh any anti-competitive effects.
And Felicity, you mentioned that dual hat and that sort of crossover between the sort of the two core objectives of the ACCC around competition and consumer law and the overlapping nature of those sort of approaches. We're seeing this in some other contexts. Chloe.
Well, yes. So, for example, the ACCC identified for the first time this year competition and consumer concerns in aviation as a priority for them. And of course, we saw the ACCC settle with Qantas just the other week for their cancelled flights saga, and that was a $100 million penalty with an undertaking to pay $20 million in consumer compensation. But this is not only a consumer issue. We see it bleed into the competition concerns in the space. For example, it was alleged at one stage that Qantas cancelled flights to protect its landing and takeoff slots at airports. And in fact, earlier this year, it was announced that the process for allocating slots at Sydney Airport was going to be reformed to try to improve competition in this space. We also saw Qantas, the ACCC last year, refuse to allow Qantas to acquire Alliance Aviation. And then, of course, just recently, we've seen the collapse of Bonza. And Bonza was much touted by the ACCC as a new entrant who would help increase competition in the space. So we are certainly seeing the issues overlap here between competition and consumer as the regulator and the government try to rein in the power of the duopoly that we have in air travel in Australia at the moment. And just a quick word on digital platforms as well. So consumer issues in the digital economy was named as a priority area this year by the ACCC. And the ACCC has been conducting reviews of digital platforms since 2017. And in fact, have been actively advocating for specific laws for digital platforms for over 18 months. But we're yet to see any actual reform in that space at the moment. I suspect that for now, the ACCC is busy with merger reforms, but I think it's a wait and see, and they will probably get to digital platforms when they've got the bandwidth.
And interestingly, just the responses to the poll question there, the one that sort of stood out as something that our audience is most concerned about is around, or the enforcement priority they think is most important is around sector-specific scrutiny. And we're certainly seeing many market studies, price inquiries directed at particular industries, but I think digital platforms is a good example of that, but also where you've got both consumer and competition issues in the one industry, and it gives the ACCC quite broad powers to investigate issues there, I suppose. And moving on slightly from the ACCC's enforcement priorities and the work that they're doing, we're seeing a bit of a shift, a recent spate of private competition law litigation rather than ACCC initiated proceedings. And of course, at the moment, there's Epic, or the owner of the computer game Fortnite, versus Apple and also versus Google, which is ongoing in the federal court. And we won't make comment on that really too extensively, given it's still being heard by Justice Beach. But Chloe, can you tell us a bit more about what's happening on the litigation front?
Sure. So we have seen an uptick in private competition law litigation in recent years. Of course, Epic, Apple, Google, as you mentioned, I think it's halfway through its 16-week trial. That also comprises 2 class action lawsuits, and it's only just one limb of the multi-jurisdictional litigation. So certainly a lot of media interest around that one. In addition, scheduled for the rest of this year and into 2025, there's Brickworks and BCG, and that is the first prosecution under Section 50 in over 40 years. So certainly one to watch there. Dialogue Consulting and Meta is another one. Sinclair and Sony, a class action, as well as a private litigation involving Tasmania Ports. So each of those are alleging misuse of market power. So just to say that it's novel to have so much Part 4 private litigation on foot, and an area to watch with interest. In terms of ACCC initiated litigation, we'll also be watching the appeals that are on foot or may be on foot in terms of the BlueScope appeal and the Hutchinson one. These are to do with the nature of threats and understandings in the context of cartel conduct, and ones that we should watch with interest as well.
And I think moving on now to the issue that I'm actually quite surprised that this is the issue that the majority of audience wants to know about. And it's the competition review on non-competes. And maybe that's because we have so many in-house corporates on the call today. So that might be a reflection of why you're interested in that. And of course, you know, mergers isn't the only thing that the ACCC is looking at. There is a competition review of non-competes at the moment, and Treasury has announced that it will look at the impact of non-compete clauses on labour markets and the economy, and explore potential areas of reform. Chloe, can you take us through what the review looks like at the moment?
Yeah, so the impact of non-competes on the economy has generated increased attention over the past year or so, or couple of years. And I guess that's culminated in the release of the issues paper by the Competition Review, and that was on the 5th of April. And that paper looks at non-compete clauses and other restraints, no poach and wage fixing agreements. As part of its consultation, the government may look at whether to remove the carve-out that currently exists for employment arrangements from the cartel laws. So that would effectively bring employment contracts under the purview of competition law. Consultation finishes on the 31st of May. So for now, it's just a wait to hear the government's response and to see next steps. But certainly of interest is that in April, the US Federal Trade Commission announced that it will be prohibiting non-compete clauses in employment contracts and be voiding existing non-compete clauses except for senior executives from September this year. So I think it's clear that might have some bearing on where to for the Australian landscape and non-competes.
And Felicity, what do you think this means in practice for businesses?
Yeah, so I think there's two buckets really of things that we're considering here, Jen. There's the no poach sort of arrangements, and that's where, you know, two businesses get in a room and decide in the same industry that they're not going to poach each other's employees. And I think, you know, the fact that there's a carve out effectively that stops those from being brought within the Competition Act is probably a little bit unusual from an international perspective, and one would question the sort of legitimate business need for that sort of restraint between entities. When we come to non-competes, you know, I think there's a lot more grey area here, and you know, I think we've been sold a story by the government which is about low-income workers, and I certainly think there's a story there, and perhaps there is an overuse of non-competes in a way that's harming movement of labour and disproportionately affecting potentially the wrong people. But there is a balance to be struck here. So the fact that the FTC is carving out senior executives illustrates that there's obviously a basis for and a need for non-competes in certain circumstances. And it is about striking the right balance between, you know, protecting business secrets, confidential information, and a business that's being built up by somebody, but ensuring somebody isn't stopped from earning a living. And people may say that that's okay for senior executives who can pay it, but perhaps so would a hairdresser who's, you know, invested a lot of money to build up a business in a local area and developed a really good client relationship and invested in training staff, who doesn't necessarily want her business or his business being undermined by, you know, having someone leave and you know, steal secrets or what have you. So, you know, I think that there is grey along the areas, and so that needs to be worked out in a way that you know, does strike the right balance. And perhaps at the moment that balance isn't necessarily in the right place.
And Trent, any thoughts from an in-house perspective on this one, or any workarounds for practitioners?
Yeah, I mean, I think my experience is that we tend to see non-competes at a more senior level, either with somebody we're attempting to employ, and we do have them at a certain level in the organisation. Look, I really appreciate the issue here, especially for specialists in an industry and their prospects of work within that industry might be restrained if they were to move. However, most people with non-constraints are, as I said, quite senior in my experience anyway, and they tend to find ways around it. Either you take a longer period of leave, or you might challenge it to your ex-employer. I've seen it where people have left the restrained territory, had their new employer take them to another country for a period until they could come back. And, they use that as an opportunity to learn in another jurisdiction. I can see the concern with them. I do also have a concern, as Felicity said, as confidential NDAs and the confidentiality terms in an employment contract can only go so far. And whilst your ex-employee might not be leaving with hard copy documents or soft copy documents, there's certainly a lot in their heads of people who leave. So I think there probably is some justification for a reasonable period of a restraint in a contract with a more senior person, with no poach clauses. I mean, I think with those, we tend to be the recipient of those. Usually, when a provider wants to provide services to it, and we see a clause in there that says, "And you won't poach any of our staff for a year." Now, we tend to resist those, and I really. Personally, and I think as a company, we don't like them. I don't think it makes sense to not be able to talk to people in another large organisation if they want to turn up. And often there's a carve out in those that says unless they respond to a normal ad or whatever it is. But we tend to resist them, and I think I'd be a supporter probably of them not being in the form that we probably see them.
And one of the questions that's come through on the chat, and I might turn to you, Trent, put you on the spot here, is around the importance assigned to culture within an organisation in managing relations with the ACCC. Do you have any thoughts on that? The importance of culture within an organisation, or that learning piece that you spoke to earlier about having to sort of go on the front foot to educate the ACCC where there might be a misunderstanding, or you want to sort of make sure they're understanding how the market operates.
Sure. I mean, look, our experience. I mean, I didn't start out as a lawyer who did much competition work. But certainly in my role right now, it is a huge part of what I do, and a huge part of what members of the team does, and a huge part of what the CEO has to think about every day. So I've got the question right. I mean, really, culturally, internally, we spend a lot of time thinking about compliance, clearly, and have a compliant culture within the organisation that then flows through to being compliant, and then not getting yourself into hot water on consumer issues, for example. You might say, if you ask Qantas, it probably would have said the same thing, to be quite frank. And really, where the rubber hits the road is how you execute on lots of the day-to-day decisions that could have a negative impact if you got them wrong. And even if you got them slightly wrong, they could still have a flow-on impact where you find yourself answering questions with the ACCC. So certainly culture is a very big part of it, I think. And it's funny, when you look at people who talk about compliant cultures, you can have people who say we have a zero tolerance for compliance in these areas. We have a low level of tolerance for non-compliance in these areas. And you look at that and you think, why would you have a low level of tolerance for non-compliance? But there certainly are situations where you have to make a judgment call internally to say, if I read this in the strictest way, I would probably not do any business. So there's got to be a point where you need to make a judgment call. And that's kind of why you might have a policy like that, which then flows through to how we talk about it internally, the culture that we set. But certainly we have a high compliance culture, and that works. We do spend a lot of time talking to the ACCC. The CEO meets the chair. We meet with the ACCC regularly. Scams, you mentioned earlier, we meet regularly to talk about how we can coordinate with the ACCC to reduce the number of scams. Telco is a huge conduit for scams, unfortunately. We spend a lot of money internally trying to block voice calls and SMSs at the source. So having that collaborative relationship with the ACCC, especially when you're in the industry that we're in, we've found hugely useful. We've become a kind of a trusted voice ultimately when you're talking to the regulator or you're talking to any regulator or the ACCC. For us is, really one of the things we strive to do.
And Felicity, anything to add to that from your broad spectrum of clients? I'm sure you see differences in culture and different levels of relationships with the ACCC. Any tips on some of the good things you've seen?
Yeah, I mean, we generally see really fantastic levels of attitudes to compliance and cultures of compliance. I think people are wanting to do the right thing. Sometimes there are slips in organisations, and that happens. People make mistakes, and I think often it's the relationships with in-house counsel and them being trusted advisors to the business, which is often really critical. It's that relationship which is one of openness, where business people feel really comfortable about just sense checking something. Oh, did I remember something about this in our training session? Can I just make sure I'm on the right track here and I haven't done something wrong? That seems to be a really great or really important differentiator between the organisations which pick things up before they become too problematic and the organisations where it kind of potentially goes a bit far. And having good advisors as well helps. Someone you can call and have a chat through a problem. I'm sure I know you've got a lot of great advisors that you work with, and there are lots in the Australian legal community, the competition and consumer community. So, yeah,
definitely.
Excellent. I can see another question in the chat. Please do. We've got a few minutes remaining. If you have any other questions, please do pop those in the Q&A, I should say. There's been a question around the implications on adopting generative AI or any laws that are influencing the mergers and adopting generative AI. So obviously AI is a big topic of conversation, and how AI is being regulated is really up for grabs and the topic of a lot of discussion at the moment. Felicity, is this something you're aware of?
We've been looking at that quite a bit for a lot of our clients, Jen, and one area where it's become particularly relevant is in the consumer space, where AI is doing a lot of the writing, or AI assistants are helping customers respond to problems. And you really have to be careful, because as Rod Sims said a long time ago, there's no excuse sort of from complying with competition laws by saying, but my robot did it. And so this is just a more advanced version of a bot, and the fact that you're using it, even engaging with a third party, you really need to make sure that that AI assistant isn't engaging in misleading and deceptive conduct on your behalf in particular. So if they're sort of responding to customer inquiries or complaints, make sure that they're armed with the right information, that they've got the right algorithms and they're not doing anything wrong. On the cartel side, we know that sort of algorithms in the past, and therefore AI as an extension sort of that technological advance, have been caught up in cartels before. So setting an AI to basically reach an agreement not to undercut each other's prices if they're in different companies, belonging to different companies, or using AI to a central AI service can create sort of concerted practices, information risks, and also sort of hub and spoke cartel issues. So it's new technology, it's old rules, but they often cut in very similar ways. It's just about breaking them down and understanding what you're working with. But unfortunately, you won't necessarily escape liability.
such an interesting area and sort of all unfolding at the moment. But yeah, very interesting perspective there on collusion and having to train our AI bots and so on to do the right thing. But I'm not sure if there are any other questions. Yes, one's just come through. Do we anticipate a rush of M&A activity, especially in relation to smaller acquisitions before the changes? And if so, what impacts like delays or backlogs do we foresee? I might throw to you again, Felicity, on that one.
So Trent, would be interesting to hear your perspective on this one too, but you know, I think it's always better the devil you know, in a way, and we might very well see a bit of a rush of M&A before the reforms come into place. I don't think we can do that necessarily for foreign deals. You know, foreign deals where there's an Australian component, but it's just one of many jurisdictions where there are notifications made. But certainly, I think that's possible. Just one caveat though, Jen, you know, the rules come into force, will come into force on the 1st of January 2026, but our expectation is the look back rule will happen 3 years prior to that. We're not going to get sort of a holiday from that rule until 2029 is my expectation, although we need clarification on that. So deals that you're doing now may actually be caught in that rule from January 2026. So you do need to have a bit of an eye to the future on the application of that rule, because the materials we receive from the government do say that, you know, that involves a little bit of a look back and can bring into the scope of the regime those older deals.
Look, my view is if, although the ACCC process is a huge consideration in most M&A deals, I don't think it will drive the timing. The deals are going to be done whether they're being done for commercial reasons at the time they need to be done, and whatever the rules are at the time, the rules are at the time. But there's certainly, look, you might have some people who have a window and they can squeeze it in before, but look, I don't think it's going to have a big impact on the actual, whether you see a flood in advance of the rules going in.
Interesting times ahead. Well, thank you. I know we've got 2 minutes left, so I'd like to now just thank our panel, Felicity McMahon, Trent Sinner and Chloe Hammond. Thank you so much for your time and expertise and for being so candid with us this afternoon. And thank you to everyone else for joining this afternoon and engaging in those poll questions, and also asking some really interesting and insightful questions on AI and what might happen with merger activity in the future. Just to let you know, a recording of this webinar will be made available afterwards for you to forward to others, and you can rewatch it if you'd like. And we'll follow up with a very brief summary of what we've discussed today and some links to where you can find further information. But thanks very much for joining, and hope to see you again.